The topic for today is the revival of a promissory note and a lien or security interest or a mortgage associated with it after the expiration of the statute of limitations. All civil claims are subject to some form of limitations which are set by the legislature through statute. What a statute of limitations means is after the expiration of a certain amount of time, the ability to pursue a claim for damages is barred by the statute of limitations. So, for example, in an automobile collision in Texas, the statute of limitations is 2 years. And so if an injured person fails to file a lawsuit within 2 years of the accident, the claim is typically going to be barred by limitations. So in the instance of a promissory note, and a promissory note is an agreement to pay back money that gets borrowed or loaned, the statute of limitations in Texas is typically 4 years. Promissory notes are often accompanied by some form of security interest in either real estate or a car. For example, if you borrow money to buy a car, then you'll grant a security interest in the car you buy, so that if you don't pay, the lender can repossess the car on the security interest. If the loan is not paid back by the maturity date, then the statute of limitations begins to run. And if 4 years from that maturity date passes and the lender has not yet filed a lawsuit to collect the amount owed under the promissory note, then the statute of limitations can bar the collection of that note. And the security interest that accompanies that note can also be unenforceable as a result of the expiration of limitations on the promissory note. So, for example, a mortgage on a house might become unenforceable and foreclosure might be prevented if the statute of limitations runs out on the underlying promissory note. However, in Texas, there are circumstances where the examination of the lender's records might provide an extension, essentially, the ability to enforce the debt and collect the debt that might otherwise be barred by limitations. An example of this might be a check written after the maturity date that has in the memo line the loan number written on it and is signed by the borrower. A court might say, this is an acknowledgement of the debt that's signed by the borrower. It doesn't include anything repudiating the obligation, and so this could be treated by the court as an acknowledgement of the debt. And then a new statute of limitations period of 4 years might run from the date of that check. Similarly, a letter from the borrower to the lender saying something to the effect of, I know I owe this money and I can't pay it back right now, would potentially also be treated as an acknowledgement of the debt by a court, and again restart the running of a 4-year limitations period. If a debt has expired by limitations and then is acknowledged and a new limitations period begins to run, courts may also allow any existing security interest to be enforced because of the acknowledgement. So if the len or the security interest is barred because of limitations on the underlying promissory note, the acknowledgement can then revive the ability to enforce that security interest. And so this is an important tool for lenders who may have neglected to enforce their rights, but in their paperwork they may discover something that assists them in enforcing rights that might otherwise be expired.